Good afternoon, please be seated. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 01-23-0079CV, TWC Aviation Inc., DBA, Landmark Aircraft Management and Charter versus Worldtech Aviation, LLC. Starting with appellant, will counsel please make your announcements?
Very
good.
Chad Baruch for appellate, Your Honor.
Very good. Each side today will have 20 minutes for argument. Does appellant wish to reserve any time for rebuttal?
I'd like to reserve 5 minutes, please.
Very good. Before we begin, a couple of housekeeping matters. You guys are both experienced, and so you know this already, but I'll say it anyway. First with the lights, green obviously means begin, yellow means signifies you have 1 minute left, red obviously means stop. If we're asking you a question or you're in the middle of an answer and the light turns red, please continue your answer. And we may ask you other questions. As the light turns red, please complete your answer to those questions. You don't have to stop as soon as it turns red. One more quick thing. We've read the briefs and the case and the record, and we're very familiar with the underlying facts of the case. You don't need to do a full recitation of the facts in your limited time. So it's most helpful to us if you can just jump right into the legal issues. So with all that out of the way, we're now ready to proceed and hear from counsel for appellant.
May I ask a question? Does the court need any copies of the bench tickets?
Do you have some with you?
I do.
Yes, I do.
And does your opposing counsel have them?
He does.
Okay.
I thought they were going to be up here.
I have one, thank you.
I'm good, but thank you.
Mr. Chief Justice, and may it please the court, the most straightforward way to address the main issues in this appeal in our limited time today is by focusing on the lack of legally sufficient evidence on Worldtech's actual damages claims, and then turn to TWC's entitlement to recover on its breach of contract claim for unpaid invoices. First, Worldtech, the aircraft owner, secured a judgment based on lost profits damages without providing a complete calculation of lost net profits or evidence to support the component parts of such a calculation.
How do we know from the judgment that they were lost profit damages? Because it doesn't say that in the judgment.
Right, Your Honor. The only theory that was presented in the trial court was lost profits damages. So you can take a look at their closing statement. The parties submitted written closing statements, and the only thing that they're seeking there is what they call lost revenues. It's supposed to be a lost profits model, and we have this point that they are using the wrong term, but that is what they're seeking. I don't think it's disputed that that was the only damages that they saw.
Is there confusion in the arguments or the briefs between the words profits and revenues, or I had trouble following that in the judgment myself?
Yes, Your Honor. I think that there is confusion. I think that benefits me. In the trial court, the word profits were hardly ever used in the testimony. The only time that the word profit came up in the trial testimony is when our CFO said profit is different from revenue. But I want to make sure that it's clear that this is not a nomenclature problem. This is not, they're doing the right thing, but they're just using the wrong words for it.
I was going to ask you that question.
That was my question.
Okay, well, good.
Yeah.
Let's get right to it.
We like to ask questions here. So in the findings of fact, conclusions of law, court categorized these damages as lost charter revenue damages.
Yes, Your Honor.
So how does that fit into your argument here?
I think it helps us because I think that they failed to secure a finding of lost profits, right? That they secured a finding under the wrong measure. And because there is an express finding This court cannot imply findings to support the damages number that was awarded in the judgment. I have some slides in the bench exhibits on this sort of nomenclature issue, and I think the best place to start would be slide.
Is lost charter revenue a recoverable component of actual damages?
No, Your Honor. I mean, it's a component. They have to show revenue minus costs equals net profits, right? The figure that they ultimately had to provide evidence of and do a complete calculation of is total revenues minus total costs equals lost net profits. The Texaco versus Fan case is the one that provides the sort of formula for calculating net
Does
profits.
that have to be specifically set out in the judgment, like the formula, or in the record there's some types of representation that would be automatic deductions or things of that nature? But does it have to be a calculation in the judgment?
No, Your Honor, it did not need to be calculated in the judgment. I think that they had to provide evidence from which one could make this calculation. So they had to provide evidence of the revenues that they would have made in the new venture that they were doing with Air 7. And then they had to provide evidence of all of the costs that they would have incurred in that new venture. And while they have evidence on some costs, they do not anywhere in this record have evidence of all of the costs that they were going to incur in this new venture with Air 7. And
Is there any evidence in the record of a complete calculation? I know the case law talks about having in evidence a methodology and a complete calculation. Are both of those things in this record?
No, Your Honor. There is no complete calculation of lost profits. They never calculated revenues minus costs equals net profits, neither on a monthly basis, nor an annual basis, nor, which I think is really what's required, for the entire damages period. And to your point, that is dispositive under the Supreme Court's decision in Holt-Atherton. This court has applied the same principle in the Glatley case, which we cite in our brief, and in the Merchants Group case. Holt-Atherton says there are lots of different ways that you might calculate net profits, but once you've selected a method for calculating net profits, the party must provide a complete calculation. And when a party has not done that, the evidence is legally insufficient. Full stop, we win right there just because there is no complete calculation. They never did. Revenues minus costs equals net profits.
I think you said in your briefing, but let me ask you the question anyway. Are all the plaintiff's causes of action in this case premised on the same measure of damages?
Yes. So
Same measure of actual damages.
Yeah, so they have, I think, 4 legal theories. Set aside for 1 second the quiet title declaratory judgment. They recovered damages under conversion, breach of contract, and their fraudulent lien claim.
Which they elected to recover on.
Yes, Your Honor. And the trial court awarded the same amount of damages on all 3 claims.
Okay.
And so we argue in our opening brief, and they didn't dispute it in their response, that this must have been the same pot of damages for each of the 3 claims. And really the sort of fatal, in addition to the lack of a complete calculation, there is no evidence to support complete calculation because they don't have evidence of their total costs. And as I said, this is not just a nomenclature issue. They don't have any part of the record that even purports to be all of the costs that they are going to be incurring in this new venture with this new company. And that's unsurprising because the trial court excluded their damages experts' estimate of what likely costs would have been. The trial, he had all of these different estimates of costs that he was going to provide. We went through, and each one he admitted was not supported by objective facts, figures, or data, and the trial court excluded those estimates. So the question becomes, do they have some other evidence or estimate of all of the expenses that they were going to be incurring in this new venture with Air 7? And the answer to that is no. Their damages expert did not provide that. He expressly admitted that because his cost estimates had been excluded, he could not get to a net figure.
And there was no evidence that was actually admitted that had that information in it?
Not that had all of the costs they would have been incurring. Now, I'll give them, they may have evidence on revenue, and they may have evidence of some costs, but it's without a doubt not all of the costs. So, for instance, they rely on this letter from their new management company, this Air 7 letter. And that Air 7 letter, we've got it on slide 11 of our venture exhibits. That Air 7 letter expressly says that it does not reflect all costs, right? It says, quote, this amount is not, the monthly expenses are $36,000. Then it goes, quote, this amount is not inclusive of aircraft insurance expenses, monthly minimums, and other such maintenance care programs or manual revision services and navigation updates. So on the face of the document, it says there are other expenses besides these. Their CEO testified that this $36,000 number in the Air 7 letter is only fixed costs. That's whether or not the plane flies.
Can we find those costs anywhere else in the record?
No, Your Honor. There is no place where they have all of the costs. And
So we have to go through the record and locate it, is what you're saying? It's not all in
no,
one place?
I am saying that there is no part of this record where there
Any
is
of it's in
anything that where anybody has provided an opinion or an estimate that says, okay, you're going to have this new venture with this new company. Here are all of the costs that are associated with that new company, with this new venture, with that new company. And they have some of the fixed costs, but they don't have all of them. And I was looking through the contract yesterday, and if you look at the back of the two agreements here, they have definitions of incidental expenses and operating costs. And it goes through just this litany of all of the costs that are involved in running this kind of business. Landing fees, excuse me. Here, I've got it right here. Well, I want to make sure that I turn to my breach of contract claim, so I won't read all of these. But basically, there are a lot of different costs involved in running this kind of business, and they don't have anything that is all of them, or purports to be all of them.
I can take you to the next claim with my question unless you need to finish what you were just saying.
I would, no, I'd love to.
So, finding of fact number 19, plaintiff owes a balance of $178,156.51 on its account without interest after credit.
Yes, right.
What is that?
That is the
Is that
amount.
a breach? No, I know what that is.
Oh.
Is that a breach of contract? Is that an inferred breach of contract? Is that a?
Yeah, I mean,
And then how do I interpret that in conjunction with conclusion of law number 25 that says plaintiff performed, was ready to perform, or was excused from performing, and then conclusion of law number 31 where plaintiff's entitled to an offset against the balance owed.
right. Well,
Can you kind of take me through all that?
Yes, I will endeavor. So I think that the trial court helpfully gave me about half of the findings that I need to establish my breach of contract claim. It said that we had a valid contract. It said that plaintiff had a duty to pay us for our services, and it has this amount of unpaid invoices. And really, so we think that the conclusion of law that you referenced, where they say that they performed or were ready to perform or excuse, is supported by no legally sufficient evidence, right? We conclusively established breach. They had a duty to pay upon receipt of invoices. And then we conclusively proved, and it is undisputed, that they received a final set of all of the invoices via FedEx on March 30th, 2017. They confirmed their receipt of their invoices. On those invoices, they do not dispute a single dollar. They had 40 days to pay the amounts that were owed on those invoices, and they did not, and that was a breach.
And, sorry, I
Sorry,
need
yeah.
to, I've looked at the contracts, but it's been a few days.
Sure.
So, I'm sure I'm gonna get some of this also from, Mr. Baruch, but was there anything that your client was supposed to do in order to confirm or solemnify or establish, like, hey, you've breached the contract, official date, official communication, like, we are now under the part of the contract that tells us what happens when you've breached?
Right. So, no, we did not have to do that. Once the obligation to pay turns on their receipt of invoices. And so once they receive invoices, they have to promptly determine if they dispute any of the invoices, and within 30 days, they have to pay the undisputed amounts. If they dispute any particular line item on the invoice, they have to promptly notify us of that, and then within 10 business days of the 30-day deadline to pay, they have to negotiate a resolution. So the contract actually puts the onus on them, once they have received an invoice, to determine if they dispute any part of it, notify us of it, pay the undisputed amounts, and then negotiate over the rest. There is a provision of the contract that says for other types of breaches, besides non-payment of invoices, there is this notification process. And that's right up, I don't remember what number it is, but it's right above the part that says, quote, failure to pay any sum due to manager or within 10 days of the due date shall be a breach of contract. So I've only got about 30 seconds left. The evidence conclusively showed also that up through the date of termination, we were providing services under the contract at their insistence. Up through termination, they insisted on our continuing to perform, and were seeking benefits under the contract. They asked us to provide flights to Hawaii and New York, right up to the very last day of the contract. So they have to pay for all of the services that they requested and they received. I see I'm out of time.
Hold on, do you have any more questions?
Yeah, sure.
I don't think so. Well, I do, but I
No, go ahead.
I'm probably gonna, I'll ask both of you this. Who terminated the contract first and how?
I don't
You're
know.
like,
that,
"Oh, I wish-
I
thought
don't
was
know that that's
done."
entirely clear. I know.
Okay, good, it wasn't just me.
Yeah, I don't know that that goes one way or another
Okay.
to either side's right to recovery. I know that the trial court found that on April 13th, 2017, that's when it did terminate, and the evidence shows that up through that date,
Okay.
we were providing services and are seeking recovery for those costs that we incurred on their behalf.
Gotcha.
Do you have any more questions?
Thank you.
Thank you.
Thank you very much for your argument. We appreciate that. We're now ready to hear from counsel for appellate.
Thank you, Mr. Chief Justice, and may it please the court. I'm
Captain.
going to go in a little different order because I think the parties have kind of different priorities here, or at least attach different priorities to different issues. I'm going to start in the first half of my argument with our claim under Chapter 12 for the recorded lien, the statutory damages. Obviously, we've conceded the actuals. I'm going to talk about the partial.
I was going to ask you, so I was going to ask you about that. So
Okay.
actuals and statutory,
We get the.
what's the difference between actual damages in your cert reply brief? You say you're not going to defend the award of actual damages on this statutory claim, but will defend your statutory damages.
Yes. So I'll point you in the direction of both a case and a statute.
Yep.
12.002B says we get the greater of actuals or 10 grand in statutories.
Right.
Okay?
Right.
And the case is in our brief, so you don't have to make
Right.
a special note of it. The Nation Star mortgage brief, it just so happens that the 14th court confronted this exact situation 3 years ago. And here's what they did. I mean, exact same situation,
Yeah.
recovered actuals from the trial court. Court of Appeals says there's insufficient evidence to support them, therefore we're rendering judgment for the $10,000 in statutory damages.
Okay, that's what I was going to ask. So you're asking just for the $10,000
And attorney's fees.
and attorney's fees.
Because those were stipulated, and that's different than Nation Star. That wasn't the case there. Here, they were stipulated, They were awarded on that claim in the judgment, and they are unchallenged on appeal. So we are asking, if all else fails and it's complete disaster, we believe we still walk away with a judgment for $188,000 roughly under Chapter 12. A word about the summary judgment, because that's really important to my client, because that summary judgment is what retires the lien on the aircraft. So no matter what else happens, that's the disposal. It gives us our airplane free and clear. And of course, the court knows. The court
Let me
will
go back, I'm sorry
Yes,
to interrupt you.
let's
Let
go.
me
Yeah,
go back to
absolutely.
where we just were in terms of actual and statutory damages.
Yes.
So going back to the judgment, judgment awarded the actual damages.
Correct. And I should admit, yes.
And
Yes.
I don't see anything in the judgment where conditionally or alternatively awards the $10,000.
That is correct. All that was awarded in the judgment was
Was
the
the actual
actuals.
damage, so-
But the statutories are established as a matter of law, and I should have mentioned that. I apologize. Conclusions 38 and 39 are the only two findings necessary to impose that liability as a matter of law. They say that the lien was fraudulent and that they intended to inflict financial injury. Those are straight out of the statute, and nothing more is required to establish that claim as a matter of law. So the trial court made those findings, which entitles us, and again, I think that was the case in Nation Star as well, that entitles us to judgment as a matter of law.
So if that were the case, hypothetically, for the $10,000, and then the exemplary damages, what happens to
I
that?
think they go away.
I beg your pardon?
I don't think they support the exemplary damages. There might be a remand to determine that, but they certainly would not be affirmed. And honestly, I'd not thought about that, if I'm being completely honest. So I don't know whether that's a rendition or a remand, but I know it ain't an affirm. That's
Okay.
for sure.
Okay.
I don't think we can hold those on $10,000 of statutory damages.
And
Oh,
can I just
yeah.
clarify on conclusion of law 38?
Yes.
TWC knew that the lien was fraudulent at the time they filed the lien with the FAA. What is the evidence that supports that one?
I think we recounted about 5 or 6 pieces of evidence in our brief. There were a number of things. One is they still wouldn't release the log books, which makes no sense if they believed the lien was valid. At that point, they were fully secured and could have foreclosed on the aircraft. That was one of them. The fact that it was in a different amount than what they claimed to be owed. There were some admitted misrepresentations in the lien. It was not properly verified. I mean, I know there were 5 or 6 different pieces of evidence we pointed to in our brief on that, Your Honor. Those are the ones that I recall off the top of my head. If I may,
I got one more question
yes,
for you.
I'm working hard for $10,000
I know,
this
for
afternoon.
the $10,000, so we got $178,000 in attorney's fees. What happens with those?
Those, I believe, we keep because, again, they're not challenged, number one, and number two, they were stipulated to. The parties decided to stipulate pretrial to fees. They were awarded in connection with the claim, and there was no complaint about that, at least to my recollection. I don't remember them raising any issue with the judge about that. So we believe that would just be a render for us on that. The summary judgment, just very briefly, because I know we do want to talk about lost profits, but this is really critical. As I said, this is the lien. And I just missed the ground, right? I mean, I'm trying to be honest about that. I'd rather be embarrassed and get to the right result than otherwise. We argued on page 173 of the clerk's record that we paid more than we owed and they misapplied our payments to create this fraudulent lien balance. Our client backed that up on page 179, where he said the same thing. He said, quote, "This misapplication artificially created a balance for lien-related charges," end quote. I have ellipses in there, but that's the quote. Now, that may be wrong and it may be right, but it was the summary judgment testimony at the time, and they did not controvert it. When they filed a naked response, literally no evidence attached to it. And then they followed up, they got leave at the hearing to follow up with a business records affidavit, but again, they didn't controvert it. So my suspicion is the trial court, this was pretty simple. I doubt the trial court even thought about which law applied or whether we disproved direct storage provision or what. I think the trial court just looked at it and said, I've got one party testifying they paid him in full and don't owe it, and the other party hasn't given me any controverting testimony. Summary judgment granted. And we think that very easily should be affirmed on that basis. There simply was no fact. They argued there was a fact issue, but they didn't put in any evidence. So again, if we are right about that, that entitles us to attorney's fees. The trial court awarded us on our quiet title action and on their action to foreclose the lien, the trial court gave us a summary judgment and awarded us attorney's fees. Okay? Very quickly, on the breach of contract counterclaim, before we talk about the money, a couple things about this that I think are important. Remember, the trial court, and there are probably multiple ways the trial court could have gone here, but I think the trial court on this evidence was entitled to conclude that there never was any undisputed amount we owed. I mean, they keep talking about our obligation to pay the undisputed amount. My guy testified, remember, the very first invoices he got, they tried to sneak in $200,000 of charges from another customer of theirs. Just put them on our bill fraudulently. And he said this recurred through the whole thing. Remember, we didn't even have all the invoices till 2 weeks or 3 weeks before they terminated the contract. There's this flurry of emails, and they tell us exactly what counsel is saying. They say, hey, you got to go through the invoices and tell us what you dispute. That's on like March 22nd. And my guy writes back and he says, how am I supposed to do that? I still don't have all the invoices. That's what led to the Federal Express package on the 30th. And before our 30 days are even up, contract terminated and they steal our airplane. And that's what they did. They stole our airplane, held it hostage to try and extort payment. So I think, again, trial court could have gone the other way maybe. But on this record, could the trial court have concluded that despite ultimately what the forensic accountant said months and months later, that our performance was excused? Yeah, that seems like a plausible finding for the trial court to make. Now, I do want to very briefly, in like 60 seconds, address the only two responses they have to that excuse argument. They say, number one, it only excuses future performance. Again, though, the trial court heard evidence that these problems were at the inception of the relationship. I mean, these people had $100,000 of our money in the first 6 weeks of the relationship before we even had an invoice. We gave them 50 grand before we signed the contract. So I think, again, the trial court could have concluded this was a day one problem. And then the first invoices we get have fraudulent charges. So reasonable conclusion by the trial court. They also say that we had to elect to terminate. The Caltex case we cited says that's not true when you're acting in good faith, just trying to get the other side to perform. And that's plainly, again, the trial court could have concluded that we were trying to work through this. Remember, right before they terminated, you may recall this, despite sending us those invoices, 3 days later we get an email from their CEO saying, hey, we just need a meaningful payment. He's not asking us to pay everything. He says we need a meaningful payment. So we said, okay. And we send them 135 grand, and that's terminated and take the airplane.
Let me ask you a quick question about the liens.
Yes, sir.
I'm going to switch gears on you.
Yes, sir.
So the cause of action under, what is it, section 12.00, whatever it is, Civil Remedies Code, on the lien, that was based on the recording of the federal lien
Correct.
with the FAA, right?
Correct. Two different lien claims here.
And so my question is, wasn't there always a lien in place under Texas law, under, what is it, section 70, a mechanic's lien?
Well, we don't believe so. We believe the trial court properly held there was not, based on our evidence, or our testimony, I should say, that we paid it. We also believe they were a broker. I mean, that you have to be the provider to get that lien, and they were a broker. But I don't think the court has to get to that issue, because I think the court can stop with the uncontroverted testimony of payment. So we do not believe there ever was a valid mechanic's lien. We think the trial court properly concluded there was not. So I think I better get to lost profits, because my suspicion is that the court would like to hear something about that. And, you know, after a great deal of incredibly convoluted and confusing briefing, and I'm pointing the finger there at myself, not at my outstanding opposing counsel, this gets real simple real quick. The evidence shows that the revenue and the net profits are the same thing because there's no costs to net. None. Let me explain why, and I think I can do it in 2 minutes. First, you have to understand the difference between a fixed cost and a charter operation cost. This is not a charter airplane. That's the critical fact, right? Most of the time when this airplane takes off, it's carrying our people. The charter is just sort of our side hustle to try and snake back some of that money we spend on this airplane, okay? All of the fixed costs, and that's most of them, right? That's the note on the plane, the insurance, salary and benefits for the crew and pilot, all that. We could shut down the charter operation, and we are still going to incur those costs. They have nothing at all to do with the charter. So they are not part of the net profits calculation. And I want to give you the cite to one of your own decisions, the Levens case, L-E-A-V-E-N-S. It's 1998, Westlaw 23096, star 3. And you're going to see not identical, but kind of a similar analysis saying, well, in some contexts, fixed costs don't count for net profits because you're going to incur them anyway. Okay, and that's what we have here. So then, what about the charter operational costs? Well, in some contracts, perhaps that would matter. But there's a reason my client said, unequivocally said, the 1.1 million was a net number, and here's why. Because the contract required the charter customers to pay those costs. So in other words, yes, every time the charter takes off with a charter customer, there's a fuel cost and a landing cost, right? If you look at defendants, this is TWC's Exhibit 2, page 5, section 5.2. Plain as day, it says TWC will collect those costs from the charter customers. And when you think about it, that makes sense. Why would we pay the charter customers' cost? It's an hourly fee plus costs. So we were never going to pay those costs. Now, if you have the least bit of doubt about that, I want to remind you of, if you remember the dust up over the $33,000 lost charter, right? When the over-servicing happened, we lost a charter contract for $33,000. My guy wrote to Connolly and said, you need to pay us that. Connolly says, pound sand. Right? Then, in the midst of all those emails now, when they're just going back and forth, those 35 pages of emails, Connolly says, tell you what, you bring your account current, I'll give you the $33,000 credit. Now, that's a curious thing to say. Why wouldn't he say, you bring your account current, and I'll give you your net portion of it? I'll deduct the fuel cost, I'll deduct the landing cost, and I'll pay you the difference.
So is this methodology and quote-unquote complete calculation
Okay.
in the evidence?
Yes, and here's why. And we can talk about the basics. First, I want to just answer the complete calculation. My guy testifies absolutely unequivocally on page 96 of volume 4. He says that $1.1 million number is a net loss. Okay, that's what he said. Now, they just treat that as though he misspoke or he was wrong. But he wasn't. He was the one who had it right. That there was nothing, there's literally no costs to deduct because the fixed costs are going to happen anyway, and the charter customers are going to pay the charter costs.
Is there any evidence that there were no costs or expenses?
There's evidence, no testimony from a witness who said those words. But I believe the trial court could have inferred it from my client's statement of the net, my client's testimony about the fixed costs associated with our own operation of the plane, and the contract that says they're going to go get the money from the charter clients. I mean, I think that's a reasonable inference.
If we're going to, does the case law, I don't know if this is a law question, does the case law allow a court to make a reasonable, well, let me rephrase the question. If a court makes a reasonable inference on the calculation for lost profit damages, does that satisfy the standard of proving lost profits damages with reasonable certainty? Or to state it differently, is reasonable inference equal reasonable certainty?
Well, I don't know the answer to that directly.
Because that's kind of the fulcrum of
it's an important point.
Where we're at.
But I'm unaware of any law that says a trial court can't make a reasonable inference from the evidence about anything. I mean, literally anything.
It just comes down to, is that a reasonable
inference?
Is a reasonable inference reasonable certainty for the standard of lost profit damages?
Okay, and let me just say, I think I view those as two different issues. The first question, really the question I was answering was just simply, was there one complete calculation that accounted for costs? And my answer to that is yes, I believe there was. Now,
if we infer the lack of cost or expenses.
Maybe, but let me just say, I think they've got the burden flipped on that as well. Okay, there's a case I want to, the ERI Consultant. This is out of the Supreme Court. It's a 2010 case. 318 Southwest 3rd, 867 at 878. This is a really interesting case because it says once you, as a plaintiff, provide a facial calculation, if they want to complain about missing costs, guess what? Burden of proof shifts to them. They got to put in the evidence. I don't have to. And here's what the court said about it. Said, were this not so, every facially adequate calculation would be susceptible to an unsubstantiated challenge that something is missing. So in our view, when our guy said net 1.1, however he got there, now we can talk about whether he had a basis for getting there, but however he got there, if they wanted to argue there was stuff missing, they needed to do that. And just to sort of further underscore, because it's very interesting when you look at their closing argument. I mean, first of all, it's interesting, they never cross him. Right? I mean, he says it's a net, plain as day, clear as day. They don't ever cross him. In closing, they never say, that's not a net. He's not taking costs into it. None of that. Why? Here's why I think. Because all of the people in this trial were aviation people. I myself am not.
So the burden is, let's just go back. So the burden, and I'll read this case. I confess I haven't read this particular one. I read everything else.
Chief, I thought you'd read them all. I'm very disappointed.
So I have read them all, except for this one that you just cited. So let me understand correctly.
I'm in the universe.
But, well, I think I've read those. Let me understand this correctly then. So this case stands for the proposition that a defendant has the burden to make sure that the plaintiff accurately or correctly complies with the lost profits measure. So if a plaintiff wants to prove up lost profits, if the plaintiff puts on evidence of net revenue and says that's it, are you saying that case stands for the proposition that the defendant has the burden to point that out, otherwise that's sufficient?
No, I don't think that's quite right, and it may be better if I let the Supreme Court speak for itself.
Okay.
Well, now I've got it wrong. Where did I put it here? Okay, we have to be facially, they use the word facially adequate.
Right.
Our burden is to be facially adequate of net profits, right? And then if they want to complain about something that they think is missing in our calculation, the burden shifts to them to identify and raise it. Am I answering your question, Chief?
I think so. So facially, so then your argument is that evidence of a net number is facially adequate and shifts the burden. And so we have to decide what constitutes a facially adequate number.
I think so, yes.
Am I with you now?
Yes, sir. And I believe, Your Honor, that we are facially adequate. Now, they have arguments about why they think there's a lack of, underneath support. But the Supreme Court didn't say underneath support. They said as long as it's facially adequate.
Does this case define what, or do they just use the term and not define what what's facially adequate?
And I will confess you've overreached my memory now, Your Honor. I don't recall what the case says about that. I just know that's the phrase they use, is once we're facially adequate. But again, we feel like once our client, and by the way, again, we think the evidence shows that that's correct. I mean, the trial court could have inferred from that exchange about the $33,000 alone, I think, that the parties knew if we lost $33,000, we lost $33,000 because Connolly never comes back and says, hey, whoa, you got to pay for the fuel out of that.
So, okay, I'm way behind the chief here on this. So let me just confirm. So the fact that there was not evidence of costs, I guess I'm confused a little bit. So the damages are, here's how much money we were going to make under our agreement with Air 7. Minus what? Minus nothing?
Minus nothing, exactly. That's why it's a guaranteed amount.
Right. But
and further, to just put one more, to answer that question with one more point, the TWC contract, when it refers to the amount that goes to my client, it refers to it as a net, that's in quotation mark, net hourly reimbursement. They recognize it as a net number.
So there was never any scenario under which your client would owe Air 7 any money back?
Oh, they're absolutely. I'm sorry, I thought you were.
No, it's okay. I'm just still, I'm doing.
Sure, if the plane didn't charter, for example, if something went haywire and the plane didn't charter, we absolutely would have ended up owing them the money. But again, it's money we would have owed them either way. It's fixed costs. So no, there was never an amount we would owe them related to the charter operation. We just wouldn't get any money in return.
Do you have any questions?
Any other questions? Thank you. It's been a
Well, we-
long time since I was here, so thank you.
Well, we
for-
appreciate your argument, and thank you very much. We're now ready to hear the appellant's rebuttal argument.
Hi, Your Honor.
Okay, we're gonna ask you right off the bat, we're just gonna hit you. Can you elucidate a little bit on this facially adequate, where your esteemed friend here was arguing that if a number is put into evidence that is facially adequate, that it shifts the burden over to the defendant in terms of the lost profit calculations, and what, in your view, constitutes a facially adequate number that would shift that burden?
I think I agree with the principle, and of course, it's the Supreme Court, so I should probably agree with it. But our contention here is that there is not a facially adequate calculation.
So you're saying not facially adequate here?
Yeah,
Okay.
so take for instance this 1.1 million number. We've got that on.
So why isn't that facially adequate? And you're probably going to answer that, but just...
Sure. So that is on page 5. It is, first of all, not a calculation of anything. All right. Their lawyer asked, how would you extrapolate from an annual number to an 18.5-month number? And the CEO says, well, it would be 1.1 million per year times that. All right. That's not a calculation of anything. That is a description of how one might extrapolate, but it doesn't actually go through and do the math and show the numbers. And I want to say here that, I mean, it is very clear that when the court reads the context, read the pages around this quote, because it is clear that he is talking about our, TWC's, pre-operational. So before the contract ever started, when we're negotiating, we gave them an estimate of annual charter revenue that they would be earning. And it is clear that he is talking about that. I have the picture on the next page, slide 6. They are talking about a document that's in evidence where we estimate, where we're talking about charter revenue. And he's right that it does use the word net there. But as we point out in our reply brief, that's actually a correct use of the word net. And again, this comes back to the beginning. There's a lot of confusion here over revenue versus profit versus net numbers and all of that. And I would encourage the court to look at Texaco, where they say, well, the lack of definition on what these numbers is, that's the plaintiff's problem, right? If there's lack of clarity about that. But in this industry, the term net revenue is actually a correct number, and we quote, we talk in the reply brief, we cite Investopedia, and it explains that net revenue is an appropriate number to use when you have someone who's a salesman going out there and making sales to third parties and receiving a commission. And you can see that that's happening in this quote on slide 6. We were going to charge the customers $4,200, and we were going to get a 15% commission on that before they got any revenue. That doesn't mean that this includes all of the costs of their operation. And this idea that revenue is profits is not accurate. You know, if you're running flight after flight after flight, you're going to be incurring maintenance costs.
So
right?
if there's a net revenue, so if the evidence plays devil's advocate, so if there's evidence, sufficient evidence of this net revenue number, how do we reconcile that evidence with the finding of fact that these damages are categorized as lost charter revenue as opposed to net revenue?
Yeah, I come back to my point. The court can only imply findings when there's not an express finding. And we cite the case, it's Nguyen, Nguyen. And here they got an express finding that their damages were in the form of lost revenue. And so the court cannot imply a finding under the correct measure. But more importantly, they lack any evidence. The CEO never took revenues and subtracted costs. He didn't even say, oh, there are no costs associated with this business activity. And I think, you know, accounting is awful, right? So I think that you would need an expert to come in and say, oh yeah, these fixed costs that you're incurring, or if you have employees, or if you have costs that are not included in these numbers, like interest payments on loans or insurance, those, some portion of that should be allocated to this activity, right? Because you have these fixed costs, and you're spending half your time doing charter flights and half your time doing personal flights, and someone needed to come in and say which part of that is attributable to which. That's the amount of time.
Do you have any further questions?
Thanks.
Do you have any further questions? Then thank you very much. We appreciate your argument today, and I want to thank both sides on your briefing and your argument today. You both were outstanding, and we appreciate you having you here today. Thank you again for helping us with this case. And with that, this case is submitted, and we are adjourned. Thank you.
you.